Okay, thank you, Dr. Bradford, to give this concise version of overview of this knowledge-intensive book in, about 20 minutes. Thank you so much. So, as a leading scholar on the EU regulatory power and sought-after commentator on the EU and Brexit, Dr. Bradford coined the term Brussels effect and argue that the EU still remains a superpower that shaped the world in its image. So how well is this opinion received by the scholar in China, and what's their take on this influence of EU? So now I will turn the stage to Dr. Zhang, who will start our panel discussion, and welcome all the questions and discussion from our audience, especially from our students in Beijing and Shanghai. So Dr. Zhang.
Hello, good evening, good morning, or good afternoon, everyone. It's my great honor to moderate this session. And I should firstly thanks to the contribution made by Professor An just now. The book include as well as your presentation just now. Congratulations on this on the publication of this very interesting and insightful book. I think today we have the panelists also from Shanghai International Studies University, Fudan University, Sichuan University, and also a lawyer from Beijing office of Clifford LLP. I think that just now Helena already introduced the panelists to you, and I think firstly I would like to also introduce the research fields of these panelists. So I think they will ask the questions and make some comments from their special focus. For Professor Xin, he's a professor of international studies, Shanghai International Studies University, and his major research field is on EU, China, US economic relations and economic diplomacy. And things that in your books and also in your presentation, at the beginning, you mentioned that you talk about Brussels effect instead of Washington effect or Beijing effect. I think maybe I should firstly invite Professor Xin to make some comments or questions for the discussion with you.
Okay, could you hear me? All of the attendants here, could you hear me?
Yes.
Yes.
That's good. Now, first, I should correct that my name is Xinhua and my name is not Xin. So Xin is my surname. So my name is Xinhua. And so first, I know this book for long because just at the beginning of this year, I already saw some introduction of this book on the Amazon and on some other famous website. I should say that Brussels effect is really a very enlightening concept that could summarize the power of the European Union to export its regulatory power to many different fields of the economy in the international community. And I should also say that the reasoning within this book seemed to be quite impressive, that we could just come to understand the analytical power of the authors that could just give us a relatively big picture about how this Brussels effect actually came into being. We should say that, yes, European Union seems to be relatively more potent or more powerful than the United States or any other national economies in regulatory, in regulating the market and in exporting its preferences of regulations of many different industries of the economy. And perhaps one of the reasons is the European Union enjoys a very large market, but that market in the past was not a national market. That means that that market was not a unified one. It has been a relatively more culturally, institutionally, and regulatorily more fragmented system that actually consists of many smaller national markets. And because of this very unique characteristic that the European Union bases its supranational power of regulating the market through its persistent process of the regulation development. And yes, I admit that the Brussels effect is really very influential to the world, but also at the same time, maybe or perhaps we could see that there are also some kind of the um, um, insufficiencies or deficiencies in this Brussels effect when the European Union is trying to promote it, is trying to promote its values or rules to the world. Now, firstly is perhaps we could see that the Brussels effect is relatively more reflected on relatively more technical sectors or technical rules regulating a more specific industry or sector. And strategically, when we find, for example, what about the major principles of the global governance or the global or the multilateral trading systems of the whole world, perhaps in the on the more strategic field in the global governance in the world economy, that we could find relatively perhaps there could be some kind of the um, decreasing influence of the Brussels effect to some degree. And the second is that the Brussels effect is nowadays we could see that there is a huge competition between the United States and the European Union to compete for more sayings, to compete for more power in the forming of the new rules for some new sectors and industries. And in the new sectors and industries that are based on the emerging technologies, that perhaps to some degree the United States is taking a leading role, such as the artificial intelligence, such as the big data-based industries. So for the sectors, the industries of emerging technologies, perhaps there is a very fierce competitions between the United States and the European Union, and so the Brussels effect may not be um, so powerful in these fields. So these are my ideas when I am given the floor to make some comments. But anyway, I think this book is really a very spectacular book, very excellently written and very well organized book. It is a quite a masterpiece. Okay.
Thank you, Professor Xinhua. Professor Anu, would you like to give some response?
Yes, thank you. Thank you so much, Professor Xinhua. This was really an excellent set of observations, and I think I agree with them. I think it is very important for you to point out both the origins of the EU law and how much fragmentation there was before there was the kind of consolidation, and highlight how the European integration was really accomplished through regulation. And in the end, this goal of the EU with all these regulation was mainly to integrate the single market. The original goal was not to rule the world. It was more of an incidental side effect. But in many ways, I still think there's an advantage with the remaining fragmentation. And I would suggest that even though it may be counterintuitive, and it's true that fragmentation, for instance, of the digital single market is weakening to some extent the EU's ability to produce standards. But in many ways, the EU has been so successful in exporting the standards, and many foreign governments have adopted them, because the standards are more flexible, because they are designed to work in different member states that have different characteristics. And that makes them different, for instance, from US standards. And this flexibility embedded in, for instance, with the directives that give member states some freedom on how to implement them, make them better models for different types of economies. So I think it's a source of limitation, but occasionally a source of strength. But exactly as you pointed out, there's so much more unity today. I also agree that there are elements where the EU's power has been weakening. And one is that the EU is not only a unilateralist that only seeks to influence regulations through the Brussels effect. It is by nature, by its DNA, a multilateralist. And the EU wants to work through international organizations. Yet those organizations are having a really hard time. And the EU has had a harder time making its preferences and regulations influential through those medium. And that has sort of, I think, increased the relative significance of the Brussels effect. I also appreciate that you raised this competition on new technologies, because that's, I think, where the EU knows that the stakes are very high. And I would add China to the US and the EU in trying to compete for who is setting the standards, for instance, for artificial intelligence. And there, this is a special challenge for the EU, because normally, for instance, when it comes to data protection, we don't invent those regulations in Brussels. It was Germany, it was France, it was Sweden that went ahead with data protection. And the EU was able to build on experimentation in the member states. But with AI, there is no experience to draw on. These are, as you point out, new technologies. And the EU is trying to regulate them rapidly, given that the pace with which the technologies evolve, and without the experience of national experimentation. And there, I think the competition is fierce. And now my biggest focus will be on what will the EU try to do with the new Digital Services Act. That is the EU's attempt to make its mark. And we will see in the end of this calendar year or early January what that regulation will look like. And even though the EU is not the source of most AI, it still believes that it can regulate the way that it has been able to regulate data privacy without being the source of the most influential companies. But we will see, because I think there is a lot of attempts by the US and by China to also occupy this space with their preferred values and standards.
Yes, I agree with you. And still, we need to make perhaps more detailed observation over what is developing now in the world. Particularly, we know that the competition for an edge in the new technologies and new industries are becoming more and more fierce. And this is still developing forward. So perhaps it is too early to draw any conclusion.
Thank you. Any other panelists wanted to intervene on this aspect? Or any audience from the Beijing or Shanghai Center? If not, let me first a chance to invite Professor Zhian An from Fudan University. His research field is focused on public international law, international human rights law, and also international economic law. Now, Professor Zhian An, please.
Thank you. And oh yeah, yes. Hi, just Professor Anu. So when I hear this book, the name of this book, so I think it's very enlightened. So when I teach the EU law, because the Lisbon, particularly the Lisbon treaties, because at that time, so the norms, so the norm values, which is upheld by the EU won't try to promote this kind of the norm values just in the world. So we are also trying to know how they try to do just to promote such kind of the norms and values with the EU uphold. First, and then we can observe, so now say, as you mentioned, so the EU domestic regulations actually have the impact of the effect, which is out of the EU, in particular in the companies, or some of the regulations or the legislations which is adopted by the EU actually was in particular in China. We learn China, just take the example, and we learn quite a lot from the EU legislations. So at that time, actually, I just want to say, okay, this is kind of the legislation effect, which is a spill over out of just the EU. So, and then you give this which enlightened just the concept, which is so-called the Brussels effect. So, which is inspiring me quite a lot. So I think this is really just the smart terms of the concept. So, of course, so if you just observe the from the observations, say, okay, the EU legislations, actually they have learned or followed, or just takes example, or learned by the some countries, or so the regulations actually is adopted or is followed by the companies, or particularly multinational companies, which is not just the not only just observe this kind of the regulations, which is when their products or the goods just enter into the EU market, but also they try to take it as it is the companies, just the companies or corporations, the policy, just to promote in other places. So yes, it's true. So it's true. But then I also agree with just the Xinhua, Professor Xinhua says, because so this is now we observed several just the pacts. So is it generalized? So this is a Brussels effect in the whole scenarios. So, or it is just part of that, or it is what a stage to do that. For the stage, so this kind of the Brussels effect, they can play the roles in the international economy, And then, so I have the questions is that, so what's the roles? Because we didn't say, because the form, how they just, what's the path, the form of this kind of the effect, which have the impact on the corporations. According to just what I read your articles, it's okay, it's voluntary because the corporations just adopt it voluntarily, But this is now we say the world is different, as it says. So because the market is also different, because different markets have the different standards. Also the level, as you mentioned, because the consumers, the capacity for the consume, or just the requirements of the different market, different in the different states. Okay, so whether just the company, just the company followed this kind of the standards which are adopted by the EU or imposed by the EU in them, they also try to follow, just adopt it, just all over the world. If they want to do what's really just the force behind driven them to do that. So this is the first question. The second question is that, so what's the form? So because we're talking about it is just an impact, or it is have the impact on the company, or have the impact on the states, on the other states, the states. So if they do, so what's the form? It's through law, or it's just through the norm values. So what's the base of that? So this is what's behind it. So this is, I think, this is also another issue for the because it will say, okay, this effect is for the long time, or it is just for the short time, or it's just okay, just for so-called rational persons, because the benefit and cost, because this is now, so you follow this standard, which is adopted by the EU. So we have because the more benefits than the cost. But once, if this is the basis for that, so it's reversed. So it's maybe the change. And then there's another issue. So I remember just because the EU once, they have another cases, which is for the aviation. So for just the flight, the aviation, because they have the cabin, just try to take the tariffs for that. So it seems to me it's not very successful in the doing so to promote this kind of the standards or his just the rules. So it seems it still has something which need more just to my observations they needed to look into more what's the rationalities behind it. So what's really just okay, this kind of Brussels effect can be sustained or can uphold based upon have the more solid rationalities. So what's that? So this, I think I'm curious about that. So this is my general. But anyway, so the book and also this concept is very enlightened. I think it's inspiring. But definitely, so EU. So when you just to see, listen to what you said and read your, it's also your arguments is quite persuasive. Yes, this is a way to do that. When you mentioned in the such certain field, the industries, they do, or in fact, their regulations or they actually, the domestic regulations actually have the impact on the international trade, on the internet, on other countries. But is it for the all, or it's how can it can be lasted for the long times? So it's not only, I think it's not only just competitions between the United States and the EU, or the China and the EU, but then because of the global market, it's not only just these three states, but there's another countries. So then, because in particular, for many just developing countries, because they are also playing important roles in the forming so-called international economic orders or international legal regimes. So they put all the international rules, the rules for the in this field. So whether they are also follow that, whether the Brussels effect also have the effect on that on these countries. So this is my concerns.
Thank you, Professor Lu. I also has the same puzzle since just now you mentioned that these companies, especially multinational companies, they voluntarily comply with these rules. But if we look from the perspective of international investment law, that these investors, they have to comply actually with the law of the host state in this situation in the EU. So whether they are really voluntarily, or they just have to comply with the law of that host country. And you also mentioned that the European Union can unilaterally actually promote these rules. But if these rules can be promoted also through Sichuan or UNCTAD, whether this to change from the EU rules to international rules, whether it will be better. So this is also my puzzle. Thank you, Professor Lu. And now let's invite Professor Anu to see her response. Thank you.
Wonderful. Thank you so much. And I appreciate how Professor Lu is highlighting this question of whether this is voluntary, and then inviting us to consider the interplay between what the companies do and what the governments do and what motivates them. And I think in many ways, the question is whether this is voluntary. That in some ways, I think the Brussels effect falls between cooperation and coercion. The EU is not imposing these standards, but all the companies are not happy to do this necessarily, because the EU is not getting a foreign government's cooperation either. It does not have to. So it's somewhere between, somebody says soft coercion. I think I don't like to use that term, because in many ways, it is obviously the EU can mandate what the rules are used when the companies engage in the EU market. But the decision to extend that conduct outside of the EU, that is a business decision. And that is voluntary in the sense is that they have calculated the cost and benefits. And often the cost-benefit calculus comes down to the question how expensive or valuable it is to provide different products for different markets. And sometimes, for instance, when it comes to food safety, people have different preferences when it comes to food around the world. And sometimes it is worth providing two different varieties if it's not overly costly to do it. And if you can sell much more in the American market, if you include some, for instance, preservatives, some colors in candy that the Europeans think is harmful. But there's enough of a buying power and you don't need to pay extensively for those two production lines, so you may choose to do it. So in the end, it comes down to how technically feasible it is for you to separate the production, how economically interesting it is and feasible to separate the production. So how much scale economies there are for producing to a single standard. And often it comes also to the reputation. It is hard for Google to say that I care about Europeans' reputation, but we don't care about American data subjects, American internet users' reputation. So sometimes it is harder for them to do so. An example of when it's technically hard for the companies to choose a different kind of standard is that, for instance, African farmers, sometimes they would want to use genetically modified organisms. EU does not like the GMOs. But it is hard for the farmer to use GMOs in one part of the field, but not use them in another part of the field because there's cross-pollination. And it may be that some GMO will make its way to the European non-GMO fields, and that taints the entire crop, and they cannot export into the European market. So it's too risky to try to technically force this kind of separation. But in the end, it is more of a question of what is economically interesting and what is technically feasible, and that drives the corporate decision making. What then if we talk about whether the governments voluntarily follow what the EU does? In some instances, there may be that the EU is imposing it to some extent. For instance, when the EU includes its standards into preferential trade agreements, and when you negotiate with a country that is less powerful than the EU can pretty much set the terms. So again, not only does the EU use the Brussels effect, it uses international institutions, it uses trade agreements to export and promote its standards. And there again, yes, the other governments agree to them, but sometimes if there's a power differential, they don't have a choice if they need the access to the European market. And there are a few reasons why the governments often seem to like to copy the European rules and why they are more popular and why it's easier for them to do than copying, for instance, Chinese rules or copying American rules. One is that the EU rules are often, if they are adopted by the companies operating in different markets, these companies start promoting the EU rules. So for instance, Facebook is now lobbying and asking for the US government to adopt the GDPR type of privacy rules because they already comply with the GDPR and they want them to make that a global standard to avoid fragmentation. So often the EU standards are promoted by the foreign companies vis-a-vis their own government. So again, the EU can be passive, it can outsource the lobbying for foreign companies. But also there are additional reasons why the EU rules are attractive. So for instance, one reason is that they are precise and detailed, unlike American rules, that often you would need to do the case law by American courts in order to know what American antitrust rules are. Whereas the EU rules are very easy to copy. And it gives many governments with limited regulatory capacity a much more detailed roadmap on how to regulate. There's an additional advantage, for instance, why the EU has been so successful in exporting its rules to Africa and Latin America, is that every single EU rule exists not only in English, but in French, in Portuguese, and in Spanish. And they make it very easy for Spanish-speaking Latin American countries, for Portuguese-speaking Brazil, for French-speaking African countries to follow the EU's templates. So there are certain additional structural features why the EU law is very susceptible for exportation. And something that I already mentioned earlier, because of the EU laws have been designed to fit the diversity of EU member states, they are more flexible and hence work in different global economies. I do want to mention this aviation issue that Professor Zhian mentioned, because that is an example that I use in the book of the limits of the Brussels effect. So the EU tried to export its emissions trading scheme by extending it to the aviation industry. And the idea was that, for instance, Chinese airlines that fly from Beijing to Brussels would need to buy emissions permits, not just for the time they are flying in European airspace, but all the way from Beijing to their final destination. Or when they fly from Brussels to Beijing, again, when they leave the European airspace, the obligation would continue all the way to Beijing. This is where China pushed back, United States pushed back, India pushed back. All the powerful countries were united in saying this is going too far. And then, for instance, China started saying we're not going to buy anymore the Airbus planes. Americans threatened to withdraw purchasing Airbus planes. And that was the rare instance where the concerted effort in a high stakes dispute caused the EU to back off and say, okay, we are not extending our rule to aviation extraterritorially. But I say in the book that I don't think it's a complete loss for the European Union. What happened afterwards is that that generated the incentive to negotiate internationally. And there was an international agreement on emissions in aviation. So in many ways, the threat of the Brussels effect brought the different governments on the negotiation table, and there was an agreement, maybe not a perfect agreement, but there was an agreement. So I particularly welcome that you mentioned that example, because I thought it was a fantastic case study for the book, because it shows both the limits, but also this kind of effect on the interplay between unilateralism and international rulemaking. So thank you both for those questions.
Thank you.
Thank you. Yeah, please, Professor Lu.
Yeah, what I said, yes, you just said, okay, because still based upon, because of the quality of the regulations, which is EU adopted. And also because the companies, so I did say, because the voluntary or just the economic, how to understand the economic, the benefits, that's true. So all this actually, so, and even for the states, they're also voluntary because they want to learn. So I think this is actually, it's just like a random things, sometimes, because if the situation is changed, so maybe the decisions, the voluntary decisions, all the business decisions, or even the decisions made by the states also will be various, which also will change. So this will have the also will be actually mitigate the so-called mitigate the Brussels the effect. So whether they could be really have the impact on the member states. So then, so is there any mechanism which can be ensure or just okay, this kind of effect can play, just have the impact, have it really just this can have the Brussels effect can be also can be how can I use it? Just okay, can really play the roles in promoting just this kind of the promoting international rules or just domestic rules or even the rules for the companies. So now, because we said, because for the long times, so in the world now we are promote so-called the corporate social responsibilities. Okay, so this is also not only just okay, it's also voluntary, but now internationally, so it also has a because it is kind of the soft law, it's kind of the actually pressures on the companies. So as I said, the reputation, or in particular for those who have the big markets, in particular for the EU or in the United States or other big markets. So they have the kind of strength, the pressure for the pressure for the companies. They would like just to accept this kind of the social responsibilities. But of course, generally they says no, because they have the faith in that, because the new concept for business, the business is not only for you make money for yourself, but also the business is for the purpose of society. So they have such kind of beliefs. So this is maybe is also one of the things for the company, if they have this kind of beliefs, they are trying to adopt such kind of the rules or just the regulations, which is fit to the social responsibilities. So this is also maybe is one of the phenomena for them just to try to accept, which is high qualities regulation. So it is not only, I think, is not only, of course, finally, ultimately, it's okay. This is a for the economic purpose, but to say it's not that. So once I think I discussed this kind of issues with a professor from Ireland. So because they talk about Sichuan so-called social responsibilities, the corporate social responsibility. So we think even if that it is as a one of the tools, one of the phenomena for the business. So the company just follows such kind of the social responsibilities. They are also trying to make money. But the professor says, no, he's not for money because they believe should do that. So if it's really the believing or the belief, so then, so you have something good, which is for the common good, for the good for the people, and also for good for the business. So then the company probably will be adopted, not only just to fit to try to follow compliant with the requirements of the EU, which is imposed on them, but also try to do it in other places. Or as you mentioned, probably they also try to urge or their own company to adopt similar just regulations to do that. So probably I think behind it still has the philosophy or have some other mechanisms which can be ensured for them to do that. Otherwise, so I also have another just examples. So for the companies, EU companies, if they make investment in China, so for the environment just standards in the past, I think in the past, for China, the standard is a bit quite lower than the standard which is imposed in the EU. So what company do? Do they follow the EU standard or follow the Chinese standard? I ask a lot of companies, they say, because China has a law, now I'm just complying with the law. Just complying with the Chinese standard rather than the EU standard. So then if they only just based upon the benefit and cost or this kind of the rational economics the presumptions, so probably, so this kind of the Brussels effects, I think maybe it cannot be endured just for the long times. It will be just like the floating. Sometimes do it, sometimes just down, sometimes up, sometimes down, probably. So this is my observation, just my idea. So the opinions.
Thank you.
No, I just wanted to say thank you. I think there's a very rich set of comments there, and we could continue, and I would have many comments, but I just want to make sure that we also hear from other panelists. So maybe I refrain from commenting and say that there was much there that I think we should discuss and much more for me to think about.
Okay. We also actually here have Dr. Fan from Sichuan University. His major research area is also international human rights law and also constitutional law. Dr. Fan, can you start your comments, please?
Okay, thank you. I think it's a very good book. Can you hear me? Yes?
Yes.
Can you hear me? Okay. Well, I think it's a very good book and it's useful for my teaching. And I read that book, and honestly speaking, and this afternoon in China, I watched your presentation from YouTube in the Chicago University and the Delaware University. And from the presentation tonight, I know what is Brussels effect. But honestly, I am a teacher, a professor here teaching EU constitutional law instead of the EU environmental law and EU environmental law. So I want to share my view, my comments from the EU constitutional perspective. So the first issue I want to share with you, I talk with you, maybe it's not right, but I eagerly want to share with all the authors and all the scholars here. What is the motivation behind the Brussels effect? I think that must be the protection of fundamental rights. This is my view. Why we think that protection of fundamental rights? Because if we read some case from the ECJ, from the Court of Justice, we know that Cardi case, you know, there is a conflict between EU law and international law that EU law should take priority. And we know that there is a conflict between the EU and the US in the safety harbor case, that EU government, because they found that the data privacy of some of the users on the internet, those data has already disposed in the US. However, the US governors and the US government, they can't detect the users of the European Union. So it's not safe. At that moment, we know that ECJ has prohibited the treatment of the treaties between the EU and the US. In this sense, do you think that is hegemony? I use the word hegemony, although we know that EU is it's not a state, as you said, it's not a unilateral state. In my view, EU is the supranational government with the federalism. And at that moment, if we take this down that EU is a federalism, but not a unilateral state, how we can govern the EU? In this sense, the EU governors, you know, they usually get together in the Brussels. They need to make rules to hegemonize all the EU member states, because they are not the states. They need hegemony rules. At that moment, what is the foundation of those rules? So they should take some primary, the law. Where are the primary law come from? That must be the EU Charter on Fundamental Rights. EU Charter on Fundamental Rights set a very high standard to protect the people's rights, as we know, the right to health, the right to environmental rights, and the right to privacy. At this moment, they said that these are our constitutional foundations, even that will used for our foreign diplomacy. So if the foreign companies want to get trade in EU and they want to earn the money in EU, they must follow the EU rules. That's good. That will protect the others and protect all the EU citizens in respect of the nations. And you talk about whether Beijing effect will substitute for the EU respect. Of course, I don't think so. I don't think so, because EU standards, you know, it can protect the human rights in a moral way and in a health standards than Beijing effect. But if you talk about, if you think that just because the Beijing, the Chinese people's per capita is much lower than EU, if Chinese have the same as the EU, they will reach the same standards. I don't think so. If we look at the Eastern Europe, I think their national security is not as high as China. However, they will follow the EU rules. Why? So the family, I think the most important reason must be the fundamental rights. That is the moral foundations and also the normative foundations. Okay, that's it, my brief view. Thank you.
Thank you, Dr. Fan. Now let's invite Professor An, please.
So thank you so much, Dr. Fan. These were excellent questions. And I think all the Europeans would be grateful that you highlight to us that even though when we talk about technical standards, in many ways, these are technical standards that embody European values. For very few Europeans, the idea of GDPR, it goes beyond technical standards. It is about individual dignity. It is about human rights. It is about something that we don't think about individuals as market citizens. We think about them as embodiments of these individuals with these rights that we are trying to protect, which is why it is very difficult for the EU to back away even when there's a conflict. So right now, for instance, as you well know, there have been 2 judgments by the European Court of Justice that have invalidated the existing data transfer agreements between the United States and the EU, massively costly economically. Yet the European Court has held firm that the data cannot be transferred to the US because the individual human rights, the fundamental rights of the Europeans would be compromised. And the European Union has been willing to endure a very difficult situation because our economy would require finding a way how we can legally transfer data. But because of the nature of these, not just as any technical standard, but fundamental rights, we need to resolve this conflict. And the European Court of Justice has made it clear that we are not going to accept any small adjustment. We need to make sure that we do this properly. And when it comes to, like you described the EU as a hegemony, and in many ways, I think it is right. And the EU would itself probably want to add a word. We are a benevolent hegemon. And in many ways, I think the EU believes that what has been good for the EU is likely good for the world. And issues like safer the food supply chain is something that is not only important for Europeans, but for the world. Climate change. It's not enough that Europeans know that it's important. Europeans are willing to provide a global public good, which is the mitigation of the climate change. So in many ways, I think the European Union certainly would push back on this idea that we are regulatory imperialists and saying, no, if anything, we are a benevolent hegemon. And we are always willing to engage with other countries in deciding what is the way to develop these rules and regulations. And that in its constitutional system, the main foundation and motivation has been really to build the single market. And this external dimension has been secondary. It has been much more of an afterthought. But maybe also I would say when you mentioned the CADI decision, there also I think the EU was like a benevolent hegemon in trying to improve the quality of international and United Nations rulemaking by inserting the European value system there. So I think that for you to highlight the values and the fundamental rights nature here, including with the environmental measures, I think it's a very important part of the conversation. So thank you.
Thank you. Just now you mentioned that EU think that what is good for the EU is also good for the world. We also have these kind of feelings when talking about other promotion of EU values and principles. But the reality is that countries have different situations and also still in the different development stage. So the rules may good for the EU, but sometimes may cause some problems for other countries. So how do you view this situation?
So I think that is a very important pushback and something that the EU has been criticized for. So for instance, the EU citizens can afford to care about the environment. They can afford to care about personal privacy. They can afford to care about food safety. They can afford to care about what kind of chemicals go into the products because of the level of wealth and because it is an important value. And I think there has been criticism, for instance, that how should the EU assume that even though it's good for the EU now, the rest of the world would agree that it's good for them, given their current state of development, for instance, and given the many competing priorities that these other countries have. I think it is a very valid question to ask EU. Then the EU can either say that, look, again, with the Brussels effect, we regulate the single market, and we certainly cannot be asked not to protect these values in the EU and not to realize these preferences. But then if it's the global companies that choose to follow that, it is again not something that we can be accused of doing. But at the same time, I think for the legitimacy of what the EU does, the EU would be better off recognizing the differential impact of these rules for different types of consumers and countries with different levels of development. So for instance, when it comes to the regulation of carbon and emissions trading scheme, and the EU has now made it clear that it's willing to pursue a carbon tariff on the border. And there will be pushback from countries like China and potentially the United States, even though President-elect Biden has indicated that they would do the same thing. The EU would be wise to understand the differential obligations under international law, depending on the status of the development, in order to think about protecting limiting the pushback and also ensuring the legitimacy of its policies. So I think it's one of those that the EU is expecting that kind of pushback, and it is a criticism that cannot be fully alleviated by saying it is the market forces that does it. And I think the EU today is carrying out the impact assessment of all its regulations. And I welcome that the EU has been willing to take the comments from foreign stakeholders so that it can better understand how the EU regulations impact also constituencies in different types of economies. So that would be the right avenue, I think, to have that conversations with the EU and channel that criticism.
Thank you. Actually, apart from the panelists from the academic world, we also have a lawyer here, works in the antitrust field, and this is also one very important part of your book. So now let me invite lawyer Yong to give some comments, and maybe you can also introduce some antitrust practice in China.
Sure, many thanks. And first of all, I should say that I have not got the chance to read the whole book yet. Read several chapters provided, but I'm fortunate enough to be the last one, I think, on the channel, on the panel, so that I have got the opportunity to hear about the introduction from Professor Bradford and also the comments from all the professors. I'm an antitrust practitioner in China, so my comments will be mainly from the antitrust perspective, my practice area. I'm going to be talking about maybe three areas or three points. First of all, I think that the Brussels effect not only exists, but also matters. I like this sentence from the book of Professor Bradford very much. I totally agree with that, so I copied this sentence here directly. In recent years, I have to say that I have represented a lot of Chinese companies in their investments in Europe, globally, in fact, in Europe, and also they're providing the advice, compliance advice for their operations in Europe. And the reality here is that all the Chinese companies really, really care about the European competition law. And in fact, whenever there is a new law, new rules, new guidelines, or the amendments to the laws, rules and guidelines coming up, I have been asked by a lot of my clients to give them a presentation to introduce what are the main developments. And sometimes I say that there are also new laws in India, in Ukraine, in Brazil, and sometimes even in Japan, and they care much, much less about that. I think that the reason why they care the European competition law is not only because that they are operating or they are investing in Europe, but also because that the European law is also followed by many other countries or many other jurisdictions, which means that if they can solve the problems in Europe, they probably can solve the problem all over the world. I think that is their reaction, and also that this is reality, and that is exactly what I have been seeing in practice. And the second point that I would like to say is that whether the Brussels effect can be replaced by Beijing effect, and on this point, I have to say that I also totally agree with the professor. And I think that there is at least a long way to go for the Beijing effect to replace the Brussels effect. In fact, again, taking the antitrust law in China as example, I think that many of you know that it has only been a little more than 10 years since the adoption of the Chinese antitrust law. But in this more than 10 years, China has become one of the three most important jurisdictions in terms of antitrust law globally. This is a very, very fast development and a very big achievement. But that I think that mainly because that China is now the second largest economy in the world and probably the biggest market or one of the biggest markets in the world. So, for example, in the merger filing, when the transactions we notified to China, I've been doing that a lot. And under the law, the fine for the failure to notify is only 500,000 RMB. And I have to say that in my whole practice time and area, for all the deals that I have done, no matter how simple it is, the legal fee for doing the filing is a lot more than the fine to be potentially imposed for the failure to notify. So why our clients or why the multinational companies are still choose to file in China? Because they think that China is important. And so I think that they find it very important to comply with the Chinese law. They respect the Chinese law because China is an important market, but that does not mean that they follow or they will follow the Chinese law in terms of the antitrust. So on this, I think that I would say that from the Professor Bradford view, that is because that in addition to the economic achievement or the economic position, another factor that is important important for so-called Beijing effect or Brussels effect is the so-called regulatory capacity. I think it is exactly in this area that China is underdeveloped. Again, for the taking the Chinese antitrust law as an example, I think that the problem is that the quality of legislation in China is still much lower than the quality of the legislation in the EU. So whenever I have problems, I have questions, or I need to do research, I have to say that I start from the research in the European competition law instead of the China competition law. That is the reality. And secondly, the enforcement is not always consistent. And also, in addition to that, the decision-making process is not that transparent. That means that sometimes you will find it very difficult to follow the logic or what is really behind the decision to inform the practitioners, to inform the market players. That can accordingly make it very difficult for other market players to follow as well. If we Chinese can't follow, and we can't expect all the people around the world or all the companies around the world to follow the Chinese law. So I think that there's still a long way to go. China has made huge progress in the past 10 years, 20 years, or 40 years, but it's still not at a time to really place or even compete with the Brussels effect. And the third area, or third point that I would like to make is that there are also problems with the Brussels effect. In fact, that is something that, let me put it this way, if the Brussels effect would want to survive in the future, I think that they also need to solve the problem that they may have. And here, I also take antitrust as an example. When we are representing the Chinese companies, in particular the Chinese state-owned enterprises, in their antitrust filing or investigation in Europe, there is one area of important issue here in Europe, is the so-called independence of the Chinese state-owned enterprise. Why this issue is important is that from the European regulators' perspective, the single state-owned enterprise in China, they are not independent, and there is the government role, and there are a lot of other state-owned enterprises behind, which means that the investment or the merger conducted by one state-owned enterprise is not done by that one alone. that may be done by China Inc. And that is based on the sometimes misunderstanding of the Chinese economy or the reform of the Chinese companies. And when we are doing those kind of transactions or arguments with the European Commission, and we ask the question, if you think that the Chinese companies or Chinese state-owned enterprises are not independent, do you mean that they are allowed to enter into cartel agreements? Because if you follow this same logic, you should say that the Chinese companies are allowed to do that. But the European Commission officials said, no, let's take a kind of a case-by-case analysis. And also in recent years, I think that many people know that there are a lot of restructuring between the Chinese state-owned enterprises going on. And again, here comes the problem that the merger or the consolidation between two Chinese state-owned enterprises, whether it is notifiable even to the European Commission. Again, the European Commission's feedback is quite inconsistent with their view in other deals. They view that their view is that it is not an easy question to answer. They need to do that case by case, and we need to go through a very lengthy consultation process even to solve the problem. And when we discussed that with the European Commission, we said that, why don't you do this way? If you think that we are not independent, this transaction is even not notifiable, right? So there's no problem. And if you think that we are independent, and here we can submit the filing, and you can review from the competition law perspective, and there is also it is also a no issue transaction. You should clear that. So either way you go, you need to let us proceed with this transaction. But what the European Commission is doing in practice is that they spend a long time, even more than half a year, to really think about the independence issue. And that is something that can waste a lot of time on that. So if the European, if the Brussels effect will need to continue to have this kind of a strong influence in the world in the future, I think that they need to be more flexible, and they need to admit that this is not an either-or exercise. They must admit that there are a lot of different economy or different type of operations of companies in the world. So it is not because that we are different, we Chinese companies are different from the models adopted by the European companies, but they deserve the different treatment. And sometimes they will need to come up with a lot more practical solutions or way of thinking. And here I should say that this is an area within the European competition law which I surprisingly found that the large majority of the other jurisdictions do not follow. So this is again different from what I've talked about at the beginning, that the European competition law is the true model of many other jurisdictions, but specifically on this aspect, it is not followed. For example, in the EU government said that as long as the two companies are controlled by the Chinese government, they do not need to come to the US regulator for the notification. And in other jurisdictions like Japan, like Brazil, like many other jurisdictions, they just assume every and each undertaking to be independent. They do not follow the EU model or the approach of analysis. That is very interesting area. We just stop here. Thank you.
Thank you. Let's invite Professor Anu. Yeah, please.
Thank you so much, Mr. Bayun. This was excellent, and I learned a lot, because there's a lot that I have known about the difficulty of the EU. of figuring out how to incorporate into its analysis the complicated ownership structure of Chinese companies. And I've had many conversations with a good friend of mine, Professor Angela Chang from the University of Hong Kong, and she's working on a book on Chinese antitrust and how the Americans and the Europeans are trying to view. So I've learned a lot from her, but I really appreciate you laying out the complexities and how the EU can't have it both ways. Sometimes treat the Chinese companies as being owned by China Inc. and sometimes as separate entities, whether it's a merger control, whether it's a cartel, whether it's an abuse of a dominant position. And this is something that I completely agree with you that the EU needs to figure out how to do. I would also mention that right now we are seeing a much more assertive effort by the EU to try to tackle the issue of, for instance, Chinese companies acquiring European companies if there's a state backing. If the idea is that there's actually Chinese government funds supporting the acquisition, and especially at the time of pandemic, when there are many companies struggling, there is a fear that there is going to be more strategic acquisitions funded by Chinese governments, conducted through Chinese companies. So this is a very topical issue right now that the Europeans are trying to figure out the policy forward. One thing I also want to mention, where I think you correctly pointed out one big distinction that has allowed the European Union to be so much more influential, and that would be an impediment for the Beijing effect, at least for a long time, is that of transparency. The idea that the European Union decisions are very transparent, very easy to access. And that has often made it a very attractive template to follow. So not only you can read the law, but you can access every merger decision, every conduct decision, whether it's the merger is prohibited, whether it is accepted. That's, for instance, not the case in the United States. We only have decisions of challenges of mergers, but not the reasons why we would let the merger proceed. So the more information, the more transparency has actually allowed the European Union to bolster its international influence. And I think that has been not obviously Chinese anti-monopoly regime is so young that we do not have the same track record of how China is thinking about its decisions. But the more we can open up the thinking, the more comfort does it give to market actors and other governments in trying to understand what are the motivations and the values and the processes through which the analysis unfolds. So I just want to mainly say thank you for many of those comments, because that really gives me and helps me understand the nuance of both the strength, as you say, that people look into the European competition law and care much more about that because it tells them what happens globally. But also then I accept the invitation that to think about the challenge if the EU does not figure out how to really analyze the state-owned enterprises as part of its framework.
Thank you.
Thank you, Professor Anya. Actually, when you're talking about that, the Beijing effects will not sooner replace the Brussels effect. In general, I agree with that. But I think when we're talking about evaluate this, we need also to think about the inward aspects, in which areas. In your book, I think you focus on mainly four areas: market competition, digital economy, consumer health and safety, and environment. But I think mainly focus on commercial aspects. Actually, my PhD thesis is concerning about the EU rule of law promotion worldwide. So when I do this research, I found a very interesting concept called normative power, which promoted after the military power and civilian power, soft power, and then we call it normative power, to see that the EU has a kind of regulatory power that others will voluntarily learn and follow these rules. So my question is that whether this, when you're talking about Brussels effect, whether this is also similar to normative power, and when we're talking about other areas, whether the EU also have this kind of Brussels effects in other areas instead of apart from the four main areas you mentioned in your book.
Thank you. No, I think I'm very familiar with the normative power literature, and I think it is the literature that is needing to go through some self-reckoning right now, because if you think about what is happening to the rule of law within the EU itself, in countries like Hungary, in countries like Poland, there's an internal challenge coming from within the EU to those very values that the EU has been trying to promote externally. And I think that shows that the relative advantage of the Brussels effect that relies on market forces and the relative difficulty of exporting values, because the EU has had a mixed record in promoting values, even in its neighborhood. In some of the countries in the Mediterranean, North Africa, and in the immediate neighborhood to the east of the EU. And it is not to say that it is not important. I am actually deeply concerned of what is going on in Hungary and Poland at the moment. And I think it is a challenge that the EU needs to resolve in order to re-engage with this whole concept of normative power and being able to uphold those values in the conversations internationally. But I think it just shows the difficulty. The United States has had a lot of difficulties trying to promote rule of law and democracy abroad. European Union has had a mixed record in promoting those values abroad. And I think it just shows how much easier it is when you can leverage the role of the market power in order to be able to transform the behavior of global companies, the story of the Brussels effect, and how much more difficult it is to try to think about the normative power. And yes, I think the EU is still looked upon in many parts of the world for its values. There are many countries that admire the European Union rule of law and the governance system. But at the same time, I think it has been much more difficult to consistently promote within the EU and outside of the EU.